Welcome to the AI Executive Brief. I'm Stephen Forte. Today, a single story because a federal judge in New York just handed every CEO listening a problem that does not wait. The problem is not a hack. It is not a model release. It is a ruling, and the ruling is this. Every conversation your employees have with an AI chatbot is now evidence. The case is United States versus Heppner, decided February 17, 2026 in the Southern District of New York. The judge is Jed Rakoff, one of the most respected jurists on the federal bench, the kind of judge whose opinions other judges quote. Rakoff himself called this a question of first impression nationwide. Translation: no court had ever decided this before, now one has, and the decision is not a close call. It is 31 pages of a federal judge saying with remarkable patience that no, your chatbot is not your lawyer. Here is the payoff promise for the next 10 minutes. I am going to walk you through what the court actually ruled. I am going to tell you what discoverable really means in practice. I am going to give you the retention dilemma nobody has a clean answer to. And I'm going to tell you specifically what to do this week, not next quarter, this week. If you listen to only one episode this month, make it this one. If you listen to this one with your general counsel in the car, even better. Here is the setup. Bradley Heppner was chairman of GWG Holdings, a financial services firm that collapsed and allegedly cost investors more than $150 million. Heppner gets a grand jury subpoena. He gets told by his lawyers he's a federal target, and then he does what a lot of smart executives do when they are under pressure. He opens a chatbot, the free version of Claude, not the enterprise tier, not the team tier, the $20 nothing consumer version with the privacy policy nobody reads, the one we all use to summarize meeting notes and plan birthday parties. He is facing federal securities fraud charges, and he brings a lightly trained large language model to the fight. Over a series of sessions, he uses it to generate 31 documents, reports on his defense strategy, legal arguments he plans to raise, analysis of the charges coming his way. And here is the part that should make the hair on the back of your neck stand up. He shares those documents with his defense team at Quinn Emanuel. Quinn Emanuel is one of the best litigation firms in the country. He hands it over to them. His thought, an entirely reasonable thought from a CEO's point of view, is that once it touches his lawyers, it is privileged, protected, off limits. It was not off limits. The FBI executes a search warrant at his Dallas mansion. They seize the devices. The government moves to compel the 31 documents. The defense raises privilege, and Judge Rakoff rules from the bench. He sees, and I am quoting, not remotely any basis for any claim of attorney-client privilege. Then he issues a written opinion 1 week later that is methodical, devastating, and if you run a business, required reading. It is also in places quite funny if you enjoy federal judges dismantling arguments for sport. Let me give you the 3 findings, because every one of them matters. Finding 1, Claude is not an attorney. The court held that privilege presupposes a trusting human relationship with a licensed professional who owes fiduciary duties and is subject to discipline. A chatbot owes you nothing. The government, almost as theater, literally asked Claude whether it was a lawyer and submitted Claude's own answer as evidence. Claude said no, gracefully but firmly. The government's star witness in the privilege hearing was the chatbot itself. That was the end of prong 1. Finding 2, no reasonable expectation of confidentiality. Anthropic's terms of service, which Heppner agreed to when he clicked through, state that Anthropic collects user inputs, may use them to train the model, and reserves the right to disclose data to third parties, including governmental regulatory authorities and in connection with claims, disputes, or litigation. Every major consumer AI platform has some version of this language. Everyone, the court's reasoning was not complicated. You told the company in writing that they could hand your data to the government, and then you were surprised when the government showed up with it. Nobody read the terms. Somebody always reads the terms. It is usually a federal prosecutor. Finding 3, not for the purpose of obtaining legal advice. The defense conceded, and this is critical, that counsel did not direct Heppner to use Claude. He did it on his own. The AI's own disclaimer that it cannot provide formal legal advice sealed the point. The court also shut down the retroactive argument in that handing a document to a lawyer afterward makes it privileged. Quoting the opinion directly, non-privileged communications are not somehow alchemically changed into privileged ones upon being shared with counsel. Give them credit for the word alchemically. It is rare that a federal opinion reaches for a word that good. And then the kicker. the one that should make your general counsel call you tonight, because Heppner had previously pasted privileged information from his lawyers into Claude to get better answers. The court suggested that doing so may have waived privilege over the original attorney-client communications themselves. The blast radius runs backward. Pour your privileged memo into ChatGPT to summarize it, and you may have just handed that memo to every future adversary you will ever face. The feature that makes the tool useful is the feature that blows up the privilege, which is almost elegant in its way. Here's the fence. That was the criminal case. Maybe you're thinking, I am not going to be indicted. This doesn't apply to me. Hold that thought. Because 6 weeks ago in the Delaware Court of Chancery, a case called Fortis Advisors versus Crafton made the same point in a civil dispute, and it is worse. Crafton, the South Korean gaming conglomerate that owns Subnautica, bought a smaller studio for $500 million up front, plus a $250 million earnout. When the deal soured, Crafton's CEO opened up an AI chatbot and asked it to help him strategize his way out of the earnout, and the chatbot, being helpful, delivered. The court quoted this language at trial, a response strategy to a no-deal scenario, including a pressure and leverage package, instructions to lock down publishing platforms, and a two-handed strategy of hardball legal pressure combined with softer retention offers. The Delaware Chancery Court pulled those AI chat logs up on the screen at trial and used them as evidence that the terminations of the key employees were pretextual. The AI was not the CEO's lawyer. The AI was the CEO's star witness against the CEO. Somewhere there is a lesson about asking a machine designed to be agreeable to help you with a bad idea, but that is a separate episode. And then this, the CEO admitted at trial that he had deleted some of the AI chat logs. The court made a point of noting that deletion may factor prominently in the damages phase. Spoliation of AI records. That is a phrase that did not exist 2 years ago. It exists now, and Delaware is keeping score. So now let's talk about what discoverable actually means in plain English, because this is where CEOs get this wrong. Discoverable means your adversary has a legal right to make you produce it. A plaintiff's lawyer, a regulator, a government agency, they ask for it. You hand it over. If you do not hand it over because you destroyed it, a court can sanction you. That sanction can be monetary. It can be an adverse inference instruction to the jury, which means the judge tells the jurors to assume the destroyed evidence was bad for you. In extreme cases, it can be case dispositive. You lose the case for destroying the evidence, or in the modern version, for hitting delete conversation on a Sunday night. The trigger is not a lawsuit. The trigger is reasonable anticipation of litigation. The moment a reasonable person in your company's position would see litigation coming, a demand letter, a regulatory inquiry, a contract dispute escalating, your preservation obligation attaches. And from that moment, deleting relevant records is spoliation, including AI chat logs. The machine does not know you are in litigation. You do. The obligation is yours. And here is what sits inside those logs. HR directors asking, would this employee have a discrimination claim if we terminate them? Engineers describing proprietary algorithms in detail to troubleshoot code. CFOs running acquisition scenarios with internal numbers. Managers asking how to document a performance issue before a termination. Compliance officers asking whether a specific pattern of conduct crosses a regulatory line. Every one of those conversations, post-Heppner, is a discoverable document. People thinking out loud to what they believe is a private machine is exactly the kind of raw, unguarded material every plaintiff's lawyer in America has been dreaming about for 20 years. Christmas came early. Now, the retention dilemma. This is the part where there is no clean answer, and I want you to hear me clearly. Keep them all yours, and you expand the blast radius of every future lawsuit. The candor of AI conversations where employees think they are thinking privately is disproportionately damaging in discovery. Every careless phrasing, every hypothetical, every draft argument sits in a log somewhere. Your people are not going to self-edit their prompts. The whole point of a chatbot is that they don't have to. Delete them. And under Federal Rule 37E, if litigation was reasonably anticipated, you have just committed spoliation, which means sanctions, adverse inferences, or worse. Give them credit for the precision of the trap. Both options carry legal exposure. The only path through is a tiered retention framework written in advance, enforced consistently, and paused the instant a legal hold is issued. You might think that is unreasonable. I would tell you it is exactly what email retention looked like in 2005. And the companies that figured it out early paid a lot less than the ones that did not. And if you are in a regulated industry, it is not a framework, it is a mandate. SEC Rule 17A4 and FINRA Rule 4511 require broker-dealers to retain all business-related communications in write once read many format for years. FINRA has explicitly stated in its 2026 report that this includes generative AI chatbot communications. Sarbanes-Oxley Section 802 requires 7-year retention of audit-relevant records, including electronic communications with penalties up to 20 years in prison for willful destruction. HIPAA requires a signed business associate agreement before protected health information touches an AI platform, which consumer AI platforms do not sign, full stop. Since 2022, the SEC has collected more than $3 billion in fines for off-channel communications on WhatsApp and iMessage. AI is the next sweep. It will not be smaller. So here is what to do this week. This is the inventory. 5 moves, move 1. Your general counsel and your CISO this week issue a 1-page communication to every employee. Do not enter into ChatGPT, Claude, Gemini, or any consumer AI product. Privileged matters, HR decisions about individuals, material non-public information, patient data, trade secrets, or anything related to active litigation, signed acknowledgement. Attach Heppner as the reason. If an employee asks whether this applies to the Claude tab they have open right now, yes, it does. Move 2. Your CIO in the next 2 weeks audits every AI tool in use across your organization, including especially the tools employees expensed on their corporate cards that IT does not know about. Because they exist, they always exist. For each tool, answer 3 questions. Do we have an enterprise contract with a no training clause? What sensitive data has been entered? Can we export that user's history today in an e-discovery compatible format? If the answer to the 3rd question is no, you cannot use that tool for business purposes. Period. Move 3, your GC issues or updates, every active litigation hold this week to expressly cover AI chat logs. Consumer platforms delete history on default settings in 30 to 90 days. If you have active litigation and you have not issued the hold, you may be 30 days from a spoliation problem you do not know you have. The data is disappearing while we speak. Somebody should probably go do this before the end of the episode. Move 4. You brief your board at the next meeting. This is governance, not IT. Directors have fiduciary duty here. The Crafton case involved a CEO using AI to strategize, and the director's oversight or lack of it is part of that record now too. We didn't know our executives were doing that has never been a winning board answer. It is not going to start winning now. Move 5. Within 30 days, migrate every sensitive AI workflow to enterprise tier contracts with data processing agreements, no training covenants, audit log export, and legal hold capability. For healthcare, a signed business associate agreement. For financial services, write once, read many, compliant archiving. These features exist. They are not cheap. They are cheaper than one adverse inference instruction. And now the close. The reframe I want to leave you with, the 2000s were the email wake-up call. Companies learned internal emails are fully discoverable. The 2010s were the Slack and text message wake-up call. Off-channel communications, same rules. The 2020s are the AI wake-up call, and this one is different because AI conversations are more candid, more detailed, more strategically revealing than any medium before them, precisely because your people feel they are thinking in private. They are not. They are generating evidence on someone else's servers under someone else's terms that someone else has already written into the contract that they will hand it over if subpoenaed. So the question to take into your week is not, should we let people use AI? That ship sailed. The question is, if an opposing counsel subpoenaed every AI conversation your executive team had in the last 6 months, would you be comfortable handing them over? Would you be comfortable having your words, unedited, tangential, hypothetical, candid, read aloud in a deposition? Would you be comfortable having your CEO's brainstorm on a bad acquisition quoted at your board meeting? If the answer is no, you know what to do this week. That is the AI Executive Brief for Monday, April 20th. I am Stephen Forte. If this was useful, and I believe it was, share it with someone who needs to hear it. especially your GC, especially your CISO. I will be back Tuesday with more. Until then, stay sharp.